SJC-11851, Peterborough Oil Company, LLC, v. Department of Environmental Protection.
Still morning, Mr. Cox.
Good morning, Your Honors. My name is Robert Cox, and I am for the plaintiff appellant, Peterborough Oil Company, LLC. And as has been arranged with the court clerk, I will take 10 minutes of your time to present arguments and answer your questions on the merits of the appeal brought by Peterborough. With me is Eric Bransky, who is on an amicus brief submitted by IOMA, which is the Independent Oil Marketers Association of New England. And through arrangements with the clerk, he'll be allotted 5 minutes to address questions on the impact that the trial court's decision has on the petroleum marketers industry. If I may, in 1983, the legislature, in the Massachusetts Oil and Hazardous Material Release Prevention and Response Act, Chapter 21E, adopted a broad definition of the term oil. DEP used that definition in the so-called Zone 2 exclusion. DEP in the trial court would now have oil to mean something other than what the legislature defined that term to mean when the legislature adopted it in 1983.
Could I just ask you this, though? Let's say that DEP, in making the Zone 2 regulation, had not used the word oil, but had used whatever, the hydrocarbon.
Petroleum hydrocarbons.
Petroleum hydrocarbons,
Petroleum
yes.
hydrocarbon. Would you be here?
Probably not. Probably
So
not.
it's just the choice of word?
It is the choice of words that DEP used in adopting this
In other
statute.
words, you don't disagree with the authority of the agency in implementing 21E to, and in making this Zone 2 exception. It's got more words in it than that. In any event, in doing this, could have limited it if it had said, used that word, oil.
Correct. DEP could have adopted the regulation that it says that it intended to do, but it did not. It instead used the statutory term and the regulatory term, the word that has been in the statute since 1983. It's been amended several times since then. It's been used in DEP's regulations, but it used the term oil. Now that it has used that term, it is bound by it. The agency.
thought the whole point of creating this exception or exclusion was because there had been a determination that petroleum hydrocarbons biodegraded, right?
That is
Right,
part
and-
of the record, yes.
Right, so that's what this whole point was. Lead doesn't biodegrade.
That is correct.
MBTE doesn't biodegrade.
Well, maybe, but keep going.
Well, that's as far as I can go, actually.
But we're only talking about lead here, anyway.
We're only talking about lead, and we're talking about leaded gasoline. I mean, leaded gasoline, we all know, was used and prevalent during our lifetimes when we were teenagers and filling up our tanks. We had leaded gasoline. This was an older service station that had underground tanks.
It's
And it
not
was a
hard
release
to
of leaded gasoline.
But it's not hard to see why the type of exemption that was part of this regulation would be one that would be limited.
Correct.
It's not hard to see why petroleum hydrocarbons might have been intended to be what was allowed and nothing else.
It is not hard to see, but that is not
Not what
what,
they did. So the question is, if it's not what they did, and it was basically, it sounds like it was a drafting screw-up. And
Well-
if that's what it was, what do we do now?
Well-
Is the only option to invalidate the regulation on your theory?
yes, it is.
There's no other option.
There's no
And
other
so
option.
Peterborough, and only Peterborough, gets to get underneath this using leaded gasoline, but they can change the regulation tomorrow, and nobody else does. Is that where we are?
Well, I would
That would be fine
anticipate
with
that
you.
the department, if the court would say, no, this regulation is invalid, or you're stuck with the oil, that the department would take steps to amend the regulation to say what it intended to say. That's what I would expect. But-
Change one word
Well,
that it says is clear from the beginning, but that's all it would need to do, correct?
probably change a few more words, but they need to put it out to public comment so that we can address the issue of what the appropriate standard should be. It may be more than just petroleum hydrocarbons. It may be more or more limited than what DEP has done. But that's in a rulemaking procedure that we don't have before us yet.
Well, when there was a rulemaking procedure back in 2007 or 8,
Yes.
was Peterborough Oil Company on the scene?
They were not. There were comments that were provided to DEP, comments that were ambiguous and odd, that asked whether additives would be included. DEP gave a cryptic response, but despite the confusion by way of those comments, DEP went forward and used the term oil instead of something else that it now says that it intended to do.
Now, you argue, as does the LSP amicus brief, that DEP at times, when it uses the term oil, includes leaded oil or
That's correct.
leaded gasoline. I couldn't, tell me where it does that.
Where it uses leaded gasoline,
Where the DEP interprets the word oil to include leaded gasoline.
it has done so, and I'm not sure I have the record.
You said something about aviation.
Yes, exactly. In the record, there are a number of sites where aviation fuel releases have been identified as oil releases. And DEP does not dispute that it has treated those sites as oil sites, where there's leaded gasoline is an aviation fuel. And in the briefing, DEP is not disputing, and no party is disputing, that oil, the broad term oil, is broad enough to include leaded gasoline.
Now, pragmatically, these are cleanup sites.
Correct.
When leaded oil escapes from a tank over the course of time, will the petroleum hydrocarbon part of it dissolve, leaving only the lead, or will it all stay together?
Well, that's why I'm an attorney, not a licensed site professional. Some of it will dissolve, and some components of the gasoline will move. Some of it will stay. Some of the lead will stay there. It will absorb to soil. And our LSP says that in the long term, it will absorb to soil. DEP disputes that's one of the disputes here. But the point is that what DEP did here, it used the term, and now that's in the statute, that has been used throughout Chapter 21E and throughout the MCP in one fashion, this broad fashion, and now wants to give it different meaning. That's improper. It results in inconsistent application, as you were noting. Other sections, I think, other sections of the MCP use the term oil and include leaded gasoline.
Is there any Zone 2 exemption that you're aware of that has been allowed, that has been for leaded gasoline?
I'm aware of none. We are aware of none. That this is the first one that has really come up. This exemption, from what I have seen, again, this is not in the record, has been used sparingly and raised sparingly. DEP in the record cites two questions that were raised, again, that were not available to the public, but came out of this litigation, a Q&A where parties are asking about the scope of this limitation. And in those responses, DEP gives convoluted responses. It shows that as it seeks to show what its intent is, that intent is confused and it's contradictory. There's one question, and if you don't mind, I'll read from it here. There's one question: are EPH target analytes oil within the Zone 2 exemption? DEP's response is most, but not all EPH target analytes could be considered oil within exemption. But, and this is the quote, the definition should be the determining factor. So while we have DEP saying, look, for this exemption, we've come up with a different term. We're not, even though it says oil, we mean something else. Here, DEP is saying, well, it could be this, but look to the definition. There's an inconsistency there that DEP is saying in expressing the intent that it says it relies upon in supporting its position in this case.
Does the DEP in its other cases or in its adjudicatory decisions, does it rely on the federal definition of oil in CERCLA?
It does not, because DEP in its adjudicatory decisions is dealing solely with the MCP in Chapter 21E.
Okay, So why, is it possible that the definition of oil, as it appears in Section 2 of the state EPA, does not refer to or include leaded gasoline?
It is apparent, and there's some case law in this, and as we have in our brief, that the two were, Chapter 21E and circular, were designed to interact, with the petroleum exclusion matching up with the definition of oil in Chapter 21E, and hazardous materials matching up with hazardous substances.
But
under
DEP
circular.
has never relied on CERCLA decisions for the interpretation of Section 2.
I'm unaware of it, and I can't imagine the context, other than in this case, that has come up.
All right, thank you.
Thank you very much.
Good morning. Your Honors, Mr. Chief Justice, my name is Eric Brainsky. I am attorney on behalf of amicus IOMA, and I want to first thank the court for the opportunity to address as amicus counsel. I'd like to continue on with your discussion, Justice Spina, of whether or not the DEP has utilized CERCLA's definition of oil. CERCLA defines oil, for all intents and purposes, as petroleum. Petroleum in CERCLA is incorporated, in this court in the Griffith case, which is cited in the briefs, has incorporated that CERCLA definition of petroleum into 21E's definition of oil. So oil is actually a broader definition than the federal regulations for which 21E was promulgated after. So Justice Botsford asked, and it was a very good question, is this a Scrivener's error? Did somebody just goof up? This is where my client comes in and the industry-wide issues come in. What happens here is we're not just talking about leaded gasoline. First and foremost, the summary judgment decision creates a rule that basically says oil is limited to petroleum hydrocarbons and not to any additives such as leaded gasoline, MTBE, and others that are added into gasoline. And what we would argue, and what we've argued in our brief, is this creates a very slippery slope.
Well, let me just ask you this. Are you concerned about the use of the declaratory judgment that's part of that summary judgment order as defining oil generally for Massachusetts, or as only as that term is used in Zone 2 exemption?
Oh, I am concerned of a broader definition.
So well, that's what I'm trying to figure out. So
Yes.
it's not, you don't, I mean, Zone 2, yes, but you're really concerned because that will swallow up, that becomes the definition of the term as it is defined in .0006 of the reg and Section 2.
That's absolutely correct, Your Honor. And if the question that was asked before, if DEP had promulgated a stricter regulation for Zone 2 that said, we are going to limit the oil exclusion to petroleum hydrocarbons or define petroleum hydrocarbons, then yes, we wouldn't be here and it'd be the end of story.
That'd be fine.
But the practical effect you're going to have here if this rule stays in place is you're basically creating a rule when we drill down and we talk about the issue is you are saying if there are additives in oil, it is no longer within the definition of oil.
But this is an exemption. I mean, these products have been regulated broadly. This now is an exemption. So there's really no change in practice. It's just that a narrow band of materials has been exempted from this regulatory, or this parts of the regulatory scheme. So it's not like, oh my God, this is a change in practice. Our whole industry is going to go south. It's always been the case. If you look at the amicus brief filed by the licensed site professional association, they said there's never been any confusion about what this has meant. In the 7 years it's been enacted, we've always interpreted it the same way, exactly how DEP has interpreted it. There's no confusion in the marketplace.
Your Honor, certainly that's what they say, but the exemption is based on the definition of oil, and what the summary judgment ruling by the court said is it creates a rule that says if you're adding anything to oil, it is no longer oil.
Well, it no longer qualifies for this very specific exemption.
No, but he's saying you're saying that would be one thing, but that's not the issue, because once it becomes the definition of oil.
No, this is the summary judgment. This isn't defined. It says that the oil as defined and used in this particular exemption.
But the particular exemption defines oil, capitalized, referring and incorporating therein 21E Section 2's definition of oil. I see I have little time left.
But
I'd like to-
let me ask you, in its enforcement proceedings that have been taking place for the last 8 years, hasn't the DEP been interpreting oil to mean hydrocarbons?
Not consistently, Your Honor. and
For
in
this
fact,
exemption?
In this exemption, I can't answer that question, Your Honor. I know
Well,
that
does it make a difference if they've been doing it?
it does, because that exemption incorporates the term oil. So now we're running into inconsistency.
But it's
We're
only for
defining-
purposes of this exemption. It's for purposes of the
But the
phase two,
The
whatever.
regulations don't say that. And the summary judgment decision creates the
But
rule.
can't an administrative agency define terms by cases that have been adjudicated? Isn't that one way to define terms?
The right way to define.
No, isn't that one way to do it?
I don't think it's appropriate for an agency to inconsistently apply the same term in different regulations for different exceptions. That is a defined term by state law, and that is what the legislature intended. If you're going to define a term, let's define the term such as petroleum hydrocarbons. I wouldn't have any issue with that. But when you're using the term oil, it's going to give such leeway to say oil is not oil, and the lead case proves that. And they made the rule, and we could extend it to all terms of oil, because now we're talking about 21E's definition of oil, which is incorporated into the Zone 2 exemption,
All right,
if
thank
that
you.
makes sense.
Thank you.
Thank you, Your Honor.
May it please the court. It's contrary to the statutory scheme, and I would even respectfully suggest absurd, to suggest that the department modified its exposure point regulation in 2007 to introduce an exemption that would allow public drinking water supply to be contaminated or even potentially.
But you used the statutory, you used the word oil, and with a cap, making it clear that it's a defined term.
Yes.
And you've basically acknowledged that this was a scrivener's mistake. That it was not contrary, it was contrary to the intention to be only petroleum hydrocarbons.
The intention, the clear intention was for the exemption to apply only to petroleum hydrocarbons.
Is there
and
a
not-
reason why the word petroleum, the phrase petroleum hydrocarbon wasn't used?
It would have been, in retrospect, it would have been preferable to have used it. So there is no reason why the regulation can't be interpreted that oil
You can
means
see that it
petroleum.
does create a certain degree of confusion when you use a statutorily and regulatorily defined term that may, in some other instances, be broader.
Agreed, and so 2 points I'd like to make. First, the department has taken pains to ask this court to understand that the issue before you is a narrow issue as to how oil is to be defined in this particular regulation.
Do you have any plans to actually amend it, to just have it read petroleum hydrocarbon?
At an appropriate opportunity, we would certainly be willing to amend.
Right.
I think that
Does the term oil is defined in 310 CMR 40.006, correct?
yes.
And does oil include leaded gasoline?
It depends on the context. And case law is clearly says that there is a presumption that words will be used consistently in the same statute or the same set of regulations, but that presumption is rebuttable. And you have before you a case where the DEP acknowledges that it interprets the term oil as including leaded gasoline for certain purposes, those being in the context of notification and liability. However, in the context of the cleanup activities that are required, their oil does not include leaded gasoline. It is limited to petroleum hydrocarbons.
Have there been administrative adjudications adopting that reasoning, precisely that different use of the word oil?
I wish that there were, but there really has not been any doubt about what oil means across any of the contexts.
How can there not be doubt when you're using it differently in different, under different conditions. I mean,
there's-
who else does that?
There wasn't any doubt because during the public comment period, it was discussed what oil was intended to mean. The people that rely on these regulations, I mean, to look at the regulation that we're talking about, the exposure point regulation, it is not a regulation that ordinary people rely on. It's a regulation that LSPs use. And the LSP Association, in its amicus brief, makes clear that it has never been confused, that it understood what the intention
That's the way
was.
things should be drafted?
Excuse me?
That's the way things should be drafted? I mean, it's just a screw-up.
It's so unnecessary.
It is certainly regrettable. I do think that clearly though, in terms of what this court is being asked to do, as we've mentioned, we are asking you to interpret the word oil for this particular regulation. We are not asking you to, I mean, in fact, we are
What gives
cautioning.
us the authority to do that?
Context matters. And so the case laws that would, we have the case of Lincoln, which is, it's not cited in my brief, it's one that came to my attention in preparing for oral argument, so if I'll give you the site. The Lincoln case, 370 Mass 209, at pages 213 to 214, it discusses that there is a presumption that there'll be consistent usage, but that presumption readily yields to context. And so a term may mean different things in different
But
places.
was it talking about a statutorily and regulatorily defined term with a capital O? I mean, yes, of course, that's always true. But when you take pains to actually define the term and then use the defined term with a capital, I mean, it's just basic contract law, isn't it? I mean, you use a defined term the way the defined term is defined.
When you read the defined term oil, it is susceptible to multiple meanings.
But it's defined.
Yes, it's defined that oil is defined to mean oil in any form. I mean, it's not a particularly helpful definition, but it's been interpreted to include a petroleum exclusion on the notification liability side. But when this regulation was being considered, and they were looking at the science, and again, these are the technical people. These are the people that are focused on the actual work that needs to be done.
The agency
purpose
does
of
have
the statute.
lawyers, doesn't it?
Yes, it does. And Your Honor, I'm not in any way suggesting that this regulation it would have been better for it to have used the term petroleum hydrocarbons from the get-go instead of using oil. We've explained that it was why they thought that oil was sufficient, because when you read the definition of oil, it makes a reference to that oil is not going to include hazardous material. And when you
But
go-
it doesn't, but you use the definition of oil to include leaded gasoline with aviation fuel. And so there is an inconsistent application of the statute, isn't there? Or should the inconsistency go towards the aviation fuel as opposed to here?
It's my understanding that aviation fuel does currently still have lead as an additive. Lead as an additive to regular gasoline, of course, was phased out some years ago. And we are saying that when there is a release of leaded gasoline, whether it's aviation fuel or in the past, fuel used for automobiles, that the cleanup standards that are going to apply are going to require that the hazardous materials, that the substances of concern is the way that Chapter 21E references it. The substances of concern in that release are going to need to be cleaned up, particularly where you have the spill in a sensitive area like you have here, where it is threatening a public drinking water supply. Again, it is just never the intention of the DEP, never of the intention of the legislature to allow hazardous substances.
That may all be true, but aren't you basically asking us to redraft your regulation?
I'm asking you to apply, to give deference to the agency's interpretation of the regulation, because the term oil is susceptible to multiple, it's ambiguous. And so the interpretation that DEP has given for this regulation is a rational reading of the definition. And And in addition, the court should give deference because the DEP's interpretation of its regulation is of longstanding duration, consistent application, that's evidenced and supported by the record as well as the LSP Association's brief. It's faithful to the expressed intent at the time of promulgation, comports with the statutory language and purpose of Section 21E, Chapter 21E, Section 38G. There is just a...
Am I correct that one of the most common types of spills involving oil of any type is of a gasoline tank from various gas stations around the Commonwealth?
I don't have statistics, but I think that that's a fair thought.
Is there any gasoline that does not have an additive?
Well, currently, right, I mean, the additives, lead and MTBE and so forth, they're...
Try my question. Is there any gasoline being sold that does not include an additive to the gasoline?
I believe that lead is not an additive, although it's...
I know lead is not.
I'm not...
Corn's in there, right? Never mind.
Corn. Can we assume that there are additives?
Okay,
For purposes of your
and
question?
if your definition is only petroleum hydrocarbons, and if there are always additives, then all gasoline is going to be excluded under
no,
your definition, because all gasoline contains more than petroleum hydrocarbons.
No, Your Honor.
And why
And
is
if-
that not the case?
Okay. The whole point of this regulation was to allow releases at gasoline stations to achieve closure. And it has actually achieved its mission. There have been a number of gasoline spills that have been closed under the regulation that would not have been closed but for the exemption. In this particular case, there's ongoing monitoring. There's monitoring wells all around. And those ongoing monitoring test results show that there continues to be the presence of elevated levels of lead as well as MTBE, things that are dangerous to the public drinking water supply. So in this particular case, it's not being able, there's no regulatory closure that can be achieved yet. But the regulation has served well in other instances. And so that
because there are other kinds of additives that are biodegradable? Is that... And these aren't biodegradable in the same degree as the DEP is looking for?
There are thousands of substances, I suppose, that may be involved, but I think it's going to matter on the locality. You know, where was the spill? What is the groundwater situation at the spills, at the release site? What is the soil type, et cetera? How far away are we from where the public drinking water supply is? So there's a combination of factors. So how quickly did the cleanup occur? How effectively did the cleanup occur, and so forth? So there are a number of factors. It's not always just a yes or a no, a spill, you know, will be treated this way or that.
I'm not, according to what the judge ordered, which I guess is what you wanted, is that the phrase limited to oil, it means limited to petroleum hydrocarbons.
Yes, because of the...
I understand that you've just indicated that no gasoline is made up entirely of petroleum hydrocarbons.
Okay, so...
So that means
Gasoline-
that limited to oil, it means it does not include any gasoline? Or why is that not a fair reading? Or are you going to further define this? I mean, is this definition now appropriate, or is it limited to petroleum hydrocarbons and those additives except for certain ones? I'm trying to figure out what exactly now the definition is.
So oil is a material that's used to make gasoline. When the gasoline is going to be sold for market, there may be additives added to the mixture that are going to help performance. So when we look at, for purposes of cleanup, and we have a release of leaded gasoline, or of gasoline that has additives, it's basically a combination of things. It's a combination of materials, petroleum hydrocarbons, that are likely to biodegrade, and therefore not, you know, again, depending upon the circumstances, we're always evaluating the circumstances. And so where you have a certain distance from the drinking water well and from where the spill is, the science showed, this was part of why the exemption was developed, that by the time the petroleum hydrocarbons, that part of the gasoline, moved from here to there, it would biodegrade and not be a threat. But that piece of the gasoline for the marketplace that was an additive that threatens health. So in other words, if that gets into the drinking water supply, you ingest it, it's harmful to human health. That's the aspect of it that we need to have cleaned up.
What if there's an additive that does not threaten health?
Well, then the performance standards should be able to be met.
You're talking about additives that are really hazardous, waste.
That are hazardous, things that are present
Not
that
corn.
would cause the water to be drawn from the well to not meet the drinking water standards.
But if you, I think the question is, if you use the term petroleum hydrocarbon, are you over-limiting it? Because it means no additives at all, whether they're biodegradable or not. And is that what you mean to do?
That's not this case. That has not been vetted as an issue because nobody has raised it.
But you just told me that yes, you could have used the term petroleum, you didn't just, but you told me, you could use the phrase petroleum hydrocarbon in lieu of oil with a capital O, and that would be okay.
Right, because what we're talking about here
But Chief
is,
Justice Gantz's question is
That's
if you
what the
did that.
declaratory judgment says. You're asking us to affirm that definition.
for purposes of the exemption. So the exemption comes within a regulation, right? The regulation is the identification of exposure point regulation. And that exposure point regulation sets forth certain cleanup standards and performance standards that are going to need to take place when you're near a public drinking water supply. And
Go ahead.
and as you go through, there are certain criteria that will say there can be an exemption to certain requirements if the contamination is limited to oil. And we mean that exemption to apply when the contamination is limited to petroleum hydrocarbons because we know that those hydrocarbons are unlikely to cause a danger by the time that they might migrate or would never migrate because of the biodegradability.
I want to ask you a simple linguistics question, and it has to do with the statutory definition of oil. It says oil means, and then the last clause is, and shall not include those substances which are included in 42 U.S. Code Section 9601, and then parenthesis 14. And I take it lead is one of those substances in 42 U.S.C. Section 9601.14.
Correct.
So why isn't the statutory definition of oil, whatever it is, but it does not include anything that any oil, any petroleum product that has oil that has lead in it? I haven't heard anybody say that, and why is that?
So I think what you're asking is why isn't the definition of oil that we're applying for this exemption the same definition that we apply across the board for all other purposes?
Correct.
Okay, the answer is that to the best of my knowledge, there's been no court decision on what oil means in that context.
But if it has lead in it, why isn't it not oil?
But if I may, because this is very important, and I know that I'm running out of time, you would look to the 1989 decision in the Wilshire case. It's a federal case. It's from the Ninth Circuit. And perhaps look to your own decision in the Griffith case, which I think came out, it's cited in my brief, maybe 1993 timeframe. Yes. As to some of the complications as to why the legislature, in its wisdom, may have seen fit that when we're talking about liability for the costs and damages from cleanup, that it may have excused certain parties who would otherwise be responsible for the cost of cleanup. But that, and again, we are not looking to this case to really address that point. We think that that is something that if the current interpretation, which has been suggested to you by the Marketers Association, if that were to change, that should be changed very carefully. This exemption is not a window to disrupt the whole marketplace. This exemption is a window to take care of drinking water supply on the cleanup side. And we believe that you should affirm the declaratory judgment because it's properly focused on the subject regulation, cabining the meaning of oil to the Zone 2 exemption without disrupting the applications in other contexts, and it is consistent with the DEP's statutory mandate to address substances of concern and the legislative's intent that substances of concern not be a danger.
Thank you.
Thank you.
Thank you.